In today's video, we're going to talk about what debt collectors have to prove to be able to come after you for a debt that they've purchased. Just because a debt collector buys a debt that you used to have with the original creditor doesn't mean you have to pay it. I'm going to detail you with all of the details about the information, the documents, everything that they have to even be able to come after you for the debt. Now, before I get started on this video, I want to make an admission. One of my biggest, some people call it a fault, is that I truly believe that I could help everybody. But I know that that is not the case. I know that I cannot want to help you more than you want to help yourself. It's just not going to work, and it just sets up disappointment on both sides. So what I want to do is I want to just put my best foot forward. What I do is I give you the information, and it's up to you to determine what you want to do with it. I'm not here to try to make you do something. I'm not here to try to make you believe me over someone else. I'm not trying to make you think that I know everything and people don't know stuff. What my mission is, what my goal is to really let you know the real deal about things that's happening. I have a lawsuit right here from an individual being sued by American Express, and you know they feel that they're just not going to do anything about the lawsuit. The lawsuit is for more than $10,000. And when you don't respond to this stuff here, they get default judgments. And the consequences of a default judgment, the first one is that they can come after you for 20 years. Imagine, because you simply did not reserve your rights and respond and set forth a defense to potentially win your case, you set yourself up for 20 years of them being able to harass you legally. And then the next step, the next part of them being able to harass you legally is that they can garnish your wages 25% per paycheck. It's not per month. You used to pay the American Express card, used to pay them by the month. Debt collectors love this game because when they get that judgment, they're collecting every pay period. So if you get paid weekly, 25%, bi-weekly, 25%, monthly, 25%, it doesn't matter. They're going to get 25% of every time that you get paid. They can also garnish your bank account. They can do that. You can go and do your own research on it. Go to the ACLU and see what they're doing to people's bank accounts that live in states that they don't offer garnishments in, like Texas, North Carolina. They can also seize assets. It doesn't matter if the asset is not paid off. They will figure out a way to sell the asset and pay off the asset and take the profit from the asset. Now, what does this have to do with paying a debt collector? This right here happens when people disregard what I'm going to share with you in this video. If you are receiving a letter from a debt collector, you have to respond to that debt collection letter, or the consequences are they will put that information on your credit reports. Next step, they're going to start to put together the decision process internally if they're going to sue you or if they're going to just continue trying to harass you for the debt. So now, if you've ever wondered what debt collectors really have to prove before they can make you pay up, most people think just because they get a letter that you automatically have to pay the debt. But it's far from true. In this video, I'm going to break down what happens when your debt is sold, how debt collectors must authenticate the documents, the information that they receive from the original creditor, and also exactly what they have to prove before they can even attempt to collect or even try to take it to the next level, which is to sue you in court. So first, when you fall behind, the original creditor will say, okay, there's not going to be any payments on this account. After it reaches 120 days to 180 days, depending on the type of account it is, it will go into a charge-off process. after that charge-off process, depending on the buyer, depending on the original creditor, they're either going to sell the debt or they're going to maintain the debt. American Express maintains their debt, and they hire debt collection lawyers to sue for their debt. But in this situation, we're going to talk about it with a debt buy with credit card companies that will sell off their debt. So after the account is charged off, they will sell the debt, and then the debt buyers come into the picture, and they buy these debts for pennies on the dollar. But just because they buy them for pennies on the dollar does not mean that they don't want to get the face value of what that original debt was. So don't be fooled by people. They know, everybody knows they buy it for pennies on a dollar, but they're not in the business of settling your account for pennies on a dollar. They just are not. So get it out of your mind. This is a $1 billion industry that is setting up shop to go against people who get their debts charged off by original creditors. They're not in this to make pennies on the dollar. They're in it to make dollars on the dollar. So pay attention to what I'm sharing with you in this information. So debt buyers, what they actually get is they're getting a spreadsheet that's full of information from the original debtor, and it's going to have the last known address, account numbers, not even complete account numbers, balance information, charge off date, and it's going to also have a line for the last payment. So this is the thing that you need to understand. This is very important. If you just by simply knowing this, you can stop a lot of debt collectors. You have to say it the right way, but you can stop a lot of debt collectors. Is that they have to get what's called a chain of title. And if they don't get that information, they actually don't even have proof that they even own the debt, that they've even purchased the debt. And then they're illegally coming after you. But they get away with a lot of this stuff because people don't know to ask for it. So it's very important. Now, I know I've said a lot up to this point, and I got a lot more to say. So please like this video if you haven't done it yet. I'm going to share with you how you can actually respond to these debt collectors. So don't worry about that. But right now, what I'm doing is I'm educating you on why the solution that I'm going to give you works. So now the next thing is when collectors attempt to sue you, I'm going to just like fast forward it, but you can stop a lot of this from the beginning. But this, I think it's important to go over this information because these are the things that you would ask for initially when they send you that debt demand letter, which is a letter that's saying, hey, you have a right to dispute it. They try to keep you focused on disputing the debt, but you have a right to get this information that I'm about to share with you right now. So here are the 5 things, the 5 most important things, and there's other things, but these are some of the 5 that I want to talk about in this video. Is that they need to get you the original agreement between you and the original creditor, either sign in person or sign digitally. You need that information. You need that contract. Very important. And that contract has to be legible. It cannot be all blurry. This is something that they don't want you to know about. You need to request the chain of title, the documents, and this is showing that they've purchased your debt. It needs to have your information showing that they purchased your debt. If they don't have that information, how do you know that they actually own your debt? The next thing is you want to get the balance information. You want to get a complete accounting. You want to know the charges, the payments, the interest, rewards, everything. You have a right to get all of that information so you can reconcile the amount that they're even claiming that you owe. The next thing is the authentication of the records. This is something that a lot of people don't know about, is that they have to have a qualified custodial person on their staff that takes in those documents. And that individual is going to be the one that's going to actually have to testify if they try to take you to court that these documents are 100% true. Now, there's already a problem. There's already a problem when a company debt collector buys the debt. There's already an issue, and you've probably picked up on that because they have nothing to do with the accounting. So in actuality, can they really attest to the accounting information, or can they only attest to the documents that they've received? Right there, that should put a light bulb over your head. Now, another thing that you should always check when you're receiving these debt collection letters is this account past the legal statute of limitations according to debt to be collected in your state, or legally collected. You can have a moral obligation to pay it, but I'm talking about legally, where they can continue to come after you unless you tell them that the debt is past legal statute of limitation. They have no legal option to make you pay it, and you want them to cease all communications for the debt. If you don't tell them that and the debt is still past the legal statute of limitations, they can still send you letters, emails, and try to contact you to try to get you to pay that debt. That's something that a lot of people did not know. They're like, why are they contacting me about this debt that's past the legal statute of limitations? They're allowed to do that unless you notify them. I'm going to give you a solution for that also. So now, why most debt collectors can't prove it? Debt collectors are buying portfolios in bulk, in the thousands. And they're not used to people asking for the information that I've just shared with you. And there's even more that you can ask for, but they're not used to it. Basically, because people are just running, they don't, know how to initiate their rights. So debt collectors just have a field day with just sending out letters to people, and it gets put on their credit. When it's put on their credit in a way that's like, putting something over your head to make you have to either resolve it by either paying a settlement or, trying to fight it with a credit repair process and doing debt validation. So they use that. They use those tools that are available to them. So now the number one thing that you need to do is you need to request a debt validation whenever you receive a debt demand letter from a debt collector. It is so important. It is imperative. This will stop you from experiencing a lot of pain that is incredible. It's like, if you want to know what can I do to be proactive, is to effectively respond to that initial debt collection letter. That's going to be like your door to stopping a lot of this stuff. So before I continue with the solution, I want to go over the consequences. The consequences are, if you don't respond to that initial debt collection letter, and that is not a bill, even though it looks like a bill. If you don't respond to that appropriately, you're going to end up allowing them to put the information on your credit reports. That's how the Fair Debt Collection Practices Act is written. If you don't respond to it, it's saying, yes, I owe this. Everything that they put in this letter is yes. It even gives you the opportunity to dispute it. It tells you the time period that you have to dispute it. If you don't dispute it, it means yes. So don't dispute. What they say means yes. Because it means yes, they could put it on your credit reports, and then that opens up a whole nother can of worms, because now your credit scores go down. That's the first thing that they're going to do to you. Next thing, they try to contact you. They've utilized the tool of putting it on your credit reports to try to force you into doing something that you maybe don't want to do, because you want to stop the pain of your credit score going down. You want to get rid of this situation. So they're going to put that pressure on you using that tool. If you don't respond to it, the next thing that they're going to do is they're going to be able to take you to court, potentially, if they want to. That's up to them. They're going to end up taking you to court, and it's that by them taking you to court and you don't respond to them in court, the consequences is 20 years of a default judgment that they can come after you legally to try to collect. So your situation could be horrendous right now. I was listening to one of my talk radio shows on XM radio, and the young lady was talking about it back in 2016. She was living on Section 8 housing. Now this lady is a very successful business person. If she would have had a judgment back then in 2016, it's only 10 years in 2026 is only 10 years. They would still have another 10 years to collect. And guess what? She's not on Section 8. Not this, she was not in this situation. I'm just using her as an example because a lot of people will say their life, they think because they're going through that, they have nothing or they have very little means, job situation is down. They have this thing in their mind like nothing's going to get better. And then when things get better, all of a sudden this debt collector comes knocking on the door with a document saying, guess what? We have a judgment against you, and we see that your life has gotten better, and guess what? We want all of the money. And guess what? You can't even fight the case because you gave up your rights 10 years ago. If you live in the state of Illinois, they've just bumped it up to 30 years. 30 years to come after a person. That's half of a lot of people's lifetime. And it's half of their more than half of their earning lifetime. Hell, people work 40 years and go into retirement. This is 3/4 of that they get to hold a judgment. And even if with the 20 years, that's still half of your life, like half of your earnings life, you are putting on the line by having that judgment against you. So now let's talk about the solutions. Solution number one, if you have debt collectors and they're just sending you letters, you need to go to summonsmaster.com. You can upload that debt collection letter into Summons Master and create what I call an exclusive exclusive certified debt validation letter. And that can stop a lot of debt collectors who have purchased your debt because they're not even going to think that you would know to ask for those documents. And they know if they got them, they know if they don't have them. This can put them on the spot and stop a lot of pain early. Stop a lot of pain early. So if you have a debt collection letter, they are not suing you, a debt collection letter, go to summonsmaster.com, upload it, create that debt validation letter. It's only $27. $27 to stop the pain, to be proactive. You can't beat that. If you have debt collectors who have went to the next step, say you procrastinated, just like I said, with this person, it looks like they're going to go ahead and procrastinate. They're going to go ahead and let them get the lawsuit, but you only procrastinated by not doing a response to the debt collection letter. Now they sent you the summons. You don't want to procrastinate on that because we already know the consequences is 20 years. I don't think you want 20 years. Tell me you don't want 20 years. Tell me you want to at least put up a fight and fight it step by step. Because you can always settle in the end, but if you don't even give yourself a chance to win, you're just throwing out your rights. So you can go to summonsmaster.com, put your documents into a PDF. I just made a video on this where I was telling people, use your cell phone. Use your cell phone. Get over the document. Take your pictures of the complaint. All you need is the complaint. All of the documents up to where the last page where it has the attorney who is doing the suing for the original creditor or the debt collector. That's all you need. Make that into a PDF file, and then you upload that file in the Summons Master. It's going to create a fully formatted response to every allegation and a defense to help you win your case. Now, one of the questions that was asked of me, and a person said, well, why don't I go to an attorney to just do this? And I had told them, that's your choice. I'm not here to convince you to do anything. And they said that, they can go to the attorney, and most attorneys are going to charge somewhere around, if they even work with you, $2,500 to go through the entire process. And they usually push you towards a settlement. And let me tell you the reason why they would push you towards settlement. There is a law, and I'm going to look that up because I don't want anyone saying I don't know what I'm talking about. Okay, this is the rule. So, is ABA Model Rule of Professional Conduct 3.3, candor towards the tribunal. Rule 3.3A1. Lawyer shall not knowingly make a false statement of fact or law to the tribunal or failed to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Now, this is the catch-22 that attorneys, with the reason why they end up kind of pushing or getting people to skip the process of fighting the case and going straight to a settlement, is because if you think about it, this is one of those things, like if you already know the answer to this, you already know situations to this, you've seen where an attorney in even though this is civil, but you've seen where attorneys would ask their client, hey, you got to tell me the truth about everything. I'm not gonna say, it's attorney-client privilege, but you got to tell me the truth about this, because let me tell you the reason why. And I'm not an attorney, I'm not giving legal advice, so but I have observed and I know the reasons why. Is because when they get ready to go back into court, they have to change their defense based off of something that they already know could be a lie. They cannot go into court lying. They cannot. So that's why they'll say proving beyond a reasonable doubt, because they can't go in their line. Now, with you going into court, the individual that represents themselves, they can put forth a defense that an attorney would either be afraid to put forth or would just simply not be willing to do it. I call it throwing the kitchen sink. That's what I call it. I call it throwing the kitchen sink. And this is how I learned it. I learned this because I was once sued. Well, first I was sued by a credit card, a debt collector who bought credit card debt when I was in the military. And I knew that I did not owe $4,500. And just by me knowing that I didn't, that when I was 20, I wasn't even 20, when I was 19 years old, they didn't give me a credit card for $4,500. From my memory, it was about $100 back then. I'm 19 years old in the Army. I only made $600 a month. They're not going to give me a credit card for $4,500. They just didn't. So just by me knowing that, and I went into court, and with the back and forth, I knew on accident, like, now I'm not trying to say that I was like some smart person going through this. I was young in my 20s. But I knew by just the way that the attorney was responding, by the way that I was doing my own questioning, just because I was like, I'm not paying $4,500, that the attorney was not able to say certain things. That they, in front of that judge, they were not able to say things. I was asking the attorney questions, and the judge was asking the attorney, saying, well, you need to answer what he just asked you. This 20-something-year-old guy that you claim owes $4,500, when I was asking those questions, they were direct questions to that attorney, and that attorney could not lie because he he knew that it wasn't a fact. I started asking for all of the payment history. Show me how you came up with that $4,500. And when he started doing that, all of a sudden, he was like, can we go in the back room? He asked the judge, can we go in the back room and talk this over? And because I wanted it to go away, I said, well, maybe it was $500. And he took $500. This is the number one attorney, debt collection law firm in the United States. The number one. But this was way back then in the 1990s, before they really blew up and got in all 50 states. The number one attorney, Attorney Roush. I was up against him in court at that time for that debt. And he went to he went so low on that, when I went to take the $500, I took it to the debt collection office, his office here in Brookfield, Wisconsin. I took a $500 cashier check there, and the person who was the rep at the door said there's no way that he settled that debt for $4,500 for $500. And I said, go get him. And when she went to go get him, he said, go somewhere. Like, he was like this, go somewhere. And he took the $500 because he knew that I questioned him. He probably was thinking, you don't know what you just did to me, but I don't want to ever have to deal with any type of questions like you asked me ever again. I don't want to have to deal with that. I didn't even know that. The credit repair shop wasn't around back then in the 90s. And it wasn't around until 2006. I didn't even start helping people with these lawsuits until like around 2016, a little bit after that. It was even after that, like 2018, somewhere around. I think we've been doing it for about 5-6 years. So like 2020 started helping people with the lawsuits. And that was only because my credit repair customers were like, I'm getting sued. And I was like, okay, you can contact the attorney. Contact the attorney. The attorney didn't even help me. They pushed me into a settlement. I said, I got to come up with a solution. And then all of a sudden, I was like, you went through this before. You know what to do. Just put on paper a response that worked for you in court, but put it on paper because your clients are not going to want to go into court and start talking and saying things. They'll mess it up. So I was like, well, why don't we make a full response to the allegations, number one, so they can be compliant with the court. And then number two, why don't we put the defense so the judge could read the defense? Well, I'm transparent. I didn't know the judges would read the defense. But the judges ended up reading the defense. They were like, hey, this is the person's defense. What do you have to say about that? What do you have to say about that? And guess what? Cases were getting dismissed. They didn't even have to do any settlement. I paid a settlement, but using information, and that was just like limited back then, cases getting dismissed. What I've learned since then and what I put in the Summons Master from my training and understanding and winning cases, helping people win their cases, I'm talking about upwards, the biggest one to date, 141,000, avoiding default judgments, giving people breathing room, having people not worry because they have a defense and they submitted it and now they can get back to their life. The ball's in the court of that plaintiff attorney. It's like relief, huge relief. So if you're getting sued by a debt collector, go to summonsmaster.com, upload your documents, just like I said, take pictures of each one, get your cell phone, write over them, make sure it's clear, don't cut off any of the words on the page, and make it into one PDF file and upload it in Summons Master. And it'll create a fully formatted response to every allegation and a defense to help you win your case. If you need help with your credit, visit us at thecreditrepairshop.com, watch video, what makes us different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website, 3 scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. That's where everything starts. Thank you for your time. Subscribe to the channel. There's other links below this video. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.